And good Thursday morning to you. I am Paul Blume live in our Fox 9 streaming center. We are approaching 8:03 a.m. Thursday morning. You can see Judge Michael Waterman is on his bench. What we are waiting for is the jury. They are here to watch the cell phone video again. Let's take you out to Hudson,
We are back
Wisconsin.
on the record in State of Wisconsin versus Nikolai Mew. The attorneys are both sides of the attorneys are present. Mr. Mew is present. 12 jurors are present. When we left off yesterday, we were told that the jury wanted to view a portion of the Juwan Cockfield video again. Mr. Anderson, do you have it queued up?
Yes.
All right. And Mr. Stroffacy, you or Mr. Nelson, you all consulted about the right spot to start from?
We did, Judge.
Perfect. Let's get up the monitor, and then you can hit play. Monitor's working for everyone? Yes. Okay. Please begin.
Oh, sorry. You can take it down. I gotta reboot it. Okay.
Please stop. We don't have audio.
All right.
Who is that? Where's the culture? Who is that? Who the hell is this?
Go. It doesn't matter.
He's defending. He said he was looking for little girls. He said he was looking for little girls.
You're looking for a little girl?
Yeah.
That's exactly what he said.
Weirded us out. I even have that part on camera. Did I?
Some young ass kid.
What the hell is this guy's problem, bro? We trying to have fun. Is he gonna claim you? He's gonna claim you. We're on this motherfucker. That is on camera. That is on camera. He on camera. Oh God. Oh God, he on camera. Oh God, he on camera. He ain't a woman. He ain't a woman. You ain't a woman. He ain't a woman. You killed him.
What the fuck? What the fuck?
Wait. Does anybody need to see it again? Okay, I'm seeing no indications. Please take the jury out. Please continue your deliberations.
All rise for the jury.
Please be seated. Is there anything else for the record while we're assembled?
No.
All right, that's all. We are in recess.
And good morning again from our Fox 9 streaming center. You are watching our live gavel-to-gavel coverage of the Apple River stabbing trial from Hudson, Wisconsin. The parties there in court for just a brief few minutes. What had happened late yesterday, the jury had asked the judge, the court, to re-watch the Jawan Cockfield cell phone video. They also asked to adjourn for the afternoon yesterday. Obviously a long day. They sat through closing arguments. So far 8 days of trial, so they'd asked to adjourn, but they did want to see that cell phone video. So what the court did is they sent the jury home and then began Thursday morning right there watching the Cockfield video. I would point out that that video runs about 3 minutes, 20 seconds in total, but this jury specifically wanted to watch the 10 seconds before the physical confrontation between Nikolai Miu and Madison Cohen on the river. That is the blonde woman, all of that witness testimony that came in, who pushed who first, who touched who. Madison Cohen is in Nikolai Miu's space, personal space. He alleges that she put hands on him. Obviously, we've heard the testimony from the Carlson brothers, others, the friends of Isaac Schumann, that Nikolai Miu clearly punched, slapped, struck, hit Madison Cohen, and that's what really ignited the physical altercation beyond the yelling and the mockery and the taunting, if you will. It was that physical confrontation between Nikolai Miu and Madison Cohen that ignited it, and clearly this jury is focusing in on what they want to watch. They don't want to see the entirety of it. They want to watch from 10 seconds before the encounter to right after the stabbings occur. With that, let me take a look at our graphic just so you know who is deliberating today. We began with a jury panel of 14 yesterday. You can see the judge sent home 2 male alternates. So we are now at a 6-6 gender dynamic on that jury, 6 and 6. 2 men sent home, one in their 40s, one in their 60s. I do, if you weren't with us yesterday, I want to point out what they're doing over in Wisconsin, a little different than what I'm familiar with here in Minnesota when it comes to alternate jurors at trial. But these alternates still remain on standby. They are at home or at work, but are not to be watching, us, not to be watching the news, not to be connecting on social media, not to be talking about the case. And should something happen to one of your 12 jurors, they would then come back and jump in on deliberations at some point. But again, your dynamic there, jury dynamic there, and you look at the ages, you have, 5 in their 20s to 40s, and then 6, 7 more peers of Nikolai Miu, you would say, in their 50s. Miu now 54, he's 52 at the time, and what life experience is and how you process what you see and what you've heard during this trial. You've got 7, so a little bit of a majority there, more in Nikolai Miu's potential to maybe see it through his eyes a little more or a little better. As I head over now to our legal analyst, Marsh Halberg Criminal Defense, kind enough to join us this morning. We're going to break down some of the things we've watched and heard. I would just add, by my best math, the jury got the case around 12:30 yesterday afternoon. They went home at 4:30. There was lunch. There was, time to get in and out of the court. But I would think they put in about 3 hours of jury deliberations yesterday as they begin their second day of deliberating Nikolai Miu's fate. Marsh, I just start with you saying good morning. Thank you for joining us. The thought that this jury wants to rewatch, and this is the second time that they've asked to rewatch the video, and specifically that area in and around the confrontation between Miu and that first physical, spark, if you will. What do you make of it?
Well, I think part of that's due to I think the defense did a really good job in their closing about, talking about labeling Madison Wright Queen of the River, kind of derogatory, and saying, look at other objective things you can look at to try to determine if you really hit her. Did she have bruising? No. Did she fall down? No. Did she drop her drink? No. All these other things. So I think that at least one juror, if not more, has caused them to say, I really want to focus in on that more for what's happened.
Marsh, we weren't sure if they were going to have their own access to the video, just it had not come up specifically. And I know things operate differently in different courtrooms. Sometimes the parties agree. The judge sets, what type of evidence or what type of physical material from the trial the jury gets. I know more familiar with kind of the metro counties, maybe more technologically advanced or larger budgets, but I know sometimes juries will go back with like a video player or a laptop and a thumb drive. Clearly here they have to come back into court to watch. What do you make of that?
Yeah, kind of a big difference from Minnesota, right? What happened in Minnesota just a few years back, there's a test program in Hennepin County that then expanded statewide. That now in Minnesota, generally, when you have electronics like that, video clips, et cetera, those go back into the jury room. It used to be all they got was the electronics, but no player for it. They'd get the DVD or whatever. Now they get a player. So in Minnesota, they can play it over and over and over again. They can stop things. They can rewind. Maybe they go slow-mo. They can do whatever they want. So it's a lot different than Wisconsin, where they have to come out each individual time, which, generally, common sense will tell you that'll really limit or make it a deterrent for jurors to want to come back and watch things. The argument about not allowing the jurors to have their own player is that you'd argue that why should some evidence in a case get better treatment than other evidence? Other witnesses don't get to go back into the jury room and say their statements over and over and over again. So why should a video that in effect is a form of evidence get to be played over and over and over again? So that's kind of the argument that was against it. In this case, both sides have really said, we're so grateful the video exists, right? So they can argue that they wanted it to go back.
And obviously they have access to the hard exhibits, so meaning all of those still frames that we watch frame by frame. I think it says something that they want to see that video in real time. They need to process what was going through Nikolai Miu's mind at that time, and clearly the video matters.
It's I said early on, right? It's the video versus his testimony. If you dummy this whole thing down, I think viewers that have watched this thing for the last week or so kind of start to understand what trial lawyers understand, that in the moment, some little question, some detail may seem like a big thing, and there may be objections and fights over the exact word that is used. But after everybody kind of calms down, takes a breath, steps away for a night, comes back the next day, all those little kind of details, to a great extent, may just fall apart. People around here get sick of me saying, keep it simple, stupid. But that's my trial strategy. You boil it down to some basics and you hit it over and over again.
And you told me the other day when you were on with us, it's the video and it's his testimony. Where does it net out? I'm just curious. I'm not trying to build any sympathy here for our defendant, but he sat there, the camera, the way the photographer shot that moment where they're watching the video, he's there. You saw him bow his head a couple times. You saw his defense attorney, Aaron Nelson, put his arm around his back or give him a little pat there. Just on the human front, Marsh, you represent people who are on trial, and Miu's on trial in essence for his life. He goes to prison for life if convicted on the top count. The human angle in that room between attorney and defendant at this point in a trial, waiting on a jury, what is that like?
Very important. Again, you can argue whether this is a good or bad thing, but there's a certain amount of optics and theater that's in a courtroom. And jurors really do see that, or at least collectively they see a lot of things. So I kind of warn or tell my clients, look, I'm going to put my hand up on your shoulder and talk with you in front of the jury. I want to make sure they see that they know I'm not repulsed by you. I'm not sitting 5 feet away from you at the counsel table, that I like you. I'll even, again, a little trial trick sometimes when jurors are coming in, I'll be turning around talking to, maybe the parents, right, that are in the front row. And I want to make sure I can't say anything to the jurors, but I can make it clear to them, these are connected to this case. These are likely the parents, as you figured out, if they didn't know from testimony, for example. So you do things to try and tie the human element in with that, with your client.
Marsh, Halberg, Trial 101 Optics. I feel like I'm just sitting in your law school class. I appreciate that insight. What I want to do now is call up all of the charges, right? This jury deliberated 3 hours. We have no idea how long they are going to go. The state in the last 48 hours added what we were calling lesser included. We came in here with the top count being first-degree intentional homicide in the murder of the alleged murder of Isaac Schumann. They have since added the second-degree intentional homicide as well as the reckless homicide counts. Marsh, just on these murder counts alone, there are 4 choices now running the gamut. As in the best way to produce it, I recognize you don't necessarily try case over there in Wisconsin, but if you could loosely describe the difference between an intentional act versus a reckless act here.
Right. So people, obviously we talk about premeditated murder, developing an intentional act within your mind. intent can be formed in a second. You don't have to plan for weeks or overnight to kill somebody. You can form that intent in a moment, that it's a conscious act by you intended to occur. Versus reckless is just that. It's reckless disregard for the rights and safety of others, some kind of extreme conduct that takes away that intentional act but puts you to a recklessness. A lot of times we might think of, reckless driving 100 miles an hour in a 30 zone, right? Well, gosh, I didn't intend to hit anybody driving like that, or I didn't intend to be careless, but you did it in such a reckless way that it raises to that level. It's an interesting tactical thing. I was a prosecutor, like, as you know, Paul, for 26 years before I went to the dark side here. There's a real question about how they move forward on the strategy-wise, because they could have come out of the chute at the very beginning. They could have amended this complaint in the last 2 years and had all those counts in there. I think what their thought is, let's wait to see how the evidence comes out. This isn't a bad decision. It's just there's no right or wrong here. It's just how you choose to do it. Say, let's wait to see how the evidence comes in, then we'll pick what other charges we want to add. Defense attorneys usually push back real hard about charges being added during trial, because the argument we make to a judge is, Judge, this isn't fair. I was told I had to fight against a certain charge. I built my case on that. I asked certain questions related only to that charge. I only called certain witnesses related to that charge, or cross-examined people on that issue that way. And now I'm being told there are new charges being added that are different or have different elements. So that's not fair to me after, half the case is in. But I think the response from the judge would be, as is here, that can happen. You have to plan for that. It's really just a one-off. It's not some totally unrelated offense like drug dealing or something. So therefore, we're going to let them add those charges. But I thought the defense did a nice job in the closing of arguing. The state doesn't even know what they've got. They keep just throwing more against the wall up to the last minute, hoping you buy one of these charges.
And let me take a look at the next screen, Ryan, with the charges against those who survived their stab wounds. Again, there were some lesser includeds thrown in with these yesterday. This is the attempted first-degree intentional homicide, those who were stabbed, A.J. Martin, Riley Madison, and then the Carlson brothers, and obviously on down your screen, second-degree attempted homicide, and then the recklessly endangering safety. Again, this is versus all four of those who survived their stab wounds. In these types of counts, Marsh, does the severity of injury matter? Is that important in terms of, well, if he barely touches, one of the young men, Tony and Dante, and the injury is minimal, did he really attempt to kill them? Your thoughts on sort of injury versus charge?
Right, and that was the defense's theory to push back on that, is that they said, look, if this guy really wanted to kill these people, he would have stabbed them more than once, or one person had a couple stitches, one person had a hernia. Come on, this is not that level. That I think, as I recall, the defense, the way they put it is he's sitting there with his own group on a kind of like a friendly outing with others that day. It's not like he says, hey, I think I'm going to go over and go kill somebody. That they did a pretty good job of trying to show that really wasn't the case. It's a good strategy by the state in that I lecture on this stuff is from the prosecution standpoint. I always say prosecution is like bird hunting. When you go out, you throw a bunch of buckshot up in the air and you want one of the pellets to bring down the bird. You don't care which pellet does it, but you want one of them to do that. And the more chances or the more pellets, the more charges that the jury has to consider, the more likely they might say, I don't like most of these, but at least this one I'm willing to convict on. So the more they throw up, sometimes that can help in that it gives each side something. We caution jurors to not try to be King Solomon here, right? Split the baby half each way, both sides get something. Sometimes jurors think, oh gosh, and the judge even complimented all the lawyers at the end for what a great job they all did in their decorum and their professionalism. And the jurors, you don't want them going back and going, you know what, gosh, both of these teams of lawyers were really good people, seemed to do a good job. Let's give both something on both sides. So we'll convict on something, we won't convict on something else. Defense pushes back hard on that. We don't want that. If they prove the case, so be it, convict him. If they didn't, he's not guilty on all counts.
We have several sound bites queued up from yesterday just to get your reaction to some of the arguments made during closing arguments. But on that point of self-defense and all of the charges, there are more than 20 total counts. Do you see this as an all or nothing if the jury unanimously agrees it was the whole entire episode of self-defense? he's acquitted on all 21 or so counts, correct? Or can they find he defended himself against, say, the others? Say Isaac Schumann, maybe the jury believes that Isaac's hands were at his neck and that he could have been choked or drowned in that moment. So the stab of Isaac could be deemed not self-defense, but then the others not so. Could you find a jury kind of splitting depending on what they see in that video and the frame-by-frame photos they've watched?
And to follow up on my last comment, that's exactly what the defense is worried about, is that they could just say, look, we're going to split this. What's a reasonable, rational basis to do that on? It's the level of threat that he perceived. One thing, if a person has their hands up on your throat, okay, we get that one. Getting these other people that are more at a distance or not as hostile to you, that was over the top. So that's where they could split it. But I think there is going to be strong consideration. I think Debbie Lang, my law partner yesterday, kind of alluded to this as well, that the self-defense carries across all of them. They believe that. And then, again, you got to look at it from Mew's viewpoint, his mindset, where he was thinking, was that rational to think that they could find him not guilty on everything?
Well, let's go back.
I'm struck, Paul, too, about when you put up that graphic at the beginning. This is an old jury.
Yeah.
I mean, I don't know what the rule is in Wisconsin, but Minnesota at age 70, you have the right to not even serve if you choose not to. And you've got, two people in their 70s, one person in their 90s, yeah. I think a couple people in their 50s or 60s. So at least I think 7 out of 12 of these jurors are at least 50 years old. And that's kind of a good thing for the defense, because they have, in an artful way, kind of criticized the whole group as kind of being smart-ass young drunk kids. And old people go, I'm a boomer, I'm sick of these young millennials being smart-asses and everything else. So the hope by the state is that a couple of 20 and 30-year-olds that are in there, we're going to kind of keep it balanced and say, hey, wait a minute, don't be blanket doing that. The state, when they did their second closing, tried to raise that indignation a little bit, how horrible that was, try to paint these people almost as if they deserved it.
Well, let's take this moment and go back to yesterday, the closing arguments. Corey, can never say his name properly. Trofasi, during his closing, talking about those drunk teens. Marsh, I'll get your feedback on the backside of this.
Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drunk teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation, okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works.
And there is that reference again to that Madison Cohen, Nikolai Mew interaction. And just interesting, you think about all the circumstances here, the Carlson tubers who arrive, of course, 4 of them end up getting stabbed. They were sent over, if you remember from the testimony, Quentin Carlson, the dad who's out celebrating his birthday, sends his 2 sons over to basically play peacemaker, that he sees an older man in some trouble and not quite sure what's going on, but just this idea of, these 20-somethings were basically sent to, clean up the situation, take care of the situation, and then it devolves from there. I'm just curious, Marsha, your thoughts on Trofasi there, trying to build this as a sort of a viral moment for those teens, that Jawan Cockfield is shooting the video and that it's almost like they're trying to create a video and at the expense of humiliating Nikolai Mew.
Yeah, I thought that little clip you played was one of the stronger parts of the defense closing. You know, you don't, a bully doesn't get to scream at you to leave, and when you don't leave, you know, that they somehow are still in power at that point. But the state's pushback on this, okay, you don't have to leave, but you sure don't have the right to go stab somebody either. So there's somewhere in between. And sometimes we just should be the bigger person. You're the grown up, walk away. These are drunk, stupid kids. Just let them have their moment, just walk away. And certainly that the defense is saying he didn't have to go and there was nowhere to go. I think the state, if they could have commented right there, would have said, he maybe didn't have to go, but there were lots of places to go. There's lots of open water. These people aren't like surrounding him in a tight circle. He could have just left.
Well, let's switch gears here, go over to the state side, listen in to the comments made by District Attorney, St. Croix County District Attorney Carl Anderson during his closings yesterday.
He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nikolai is this feeble old man, they ignore that the only 2 people actually standing close to Nikolai are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nikolai run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nikolai to try to explain this transition. From 0 fear to 10 out of 10 fear, he's got to take out his knife. Tried to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. Nikolai was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? The defense had tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and respond to Nikolai punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nikolai just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nikolai did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm.
So, Marsh, a couple of things there. It's Marsh Halberg, criminal defense attorney, Halberg Criminal Defense, joining us this morning. A couple of things that jumped out at me during that. The rehearsed testimony, the suggestion that, Nikolai Miu was rehearsed and practiced. And then Carl Anderson there spinning it as, it's not, he wasn't scared. He was angry. He was humiliated. He wasn't scared. He had no right to self-defense in that moment. Your thoughts on the tactics used by the prosecutor during his closings?
Yeah, again, a good clip by the state there, didn't you think? I thought that was really good. Again, keep it simple, stupid, right? He could have just walked away. He's humiliated. He's angry. We get that. Anybody would be being called those names and taunted by these guys, but just walk away. And to have not brandished the knife, he's brought it up and said, look, back off. If he'd done that, who knows if he would have gotten charged at that point, right? So I think, again, it was a very effective way to do it. Now, in fairness, what the defense would say is he told you things that didn't happen. He said there was a smirk. When they asked you that question, he said, that's not a smirk. Again, that's a 1/24th screenshot clip you have. That's not what it was. And that wasn't the case. He isn't feeble, but he sure as heck's had surgery, a year and a half earlier. So he's not going to rock and roll with a bunch of young, strong, healthy kids.
Yeah, I'm struck just as this jury has to make a decision here. And again, I would point out we are in jury deliberations. We saw the jury, I mean, not on camera, but they were in the courtroom briefly at 8 o'clock to rewatch the Juwan Cockfield cell phone video of the deadly encounter on the river. But the way the prosecution sort of describes the subtle nature of the knife coming out, he's got it down, no one sees it, he doesn't brandish it whatsoever, he doesn't warn off, no one else is armed in that moment. You know, just, you know, again, it's a human moment. I can't put myself in Nikolai Miu's shoes at that point, but what is the scenario if he takes it out, fully displays it, and takes a couple steps back? You know, if he doesn't, by not doing that, does he really open himself up now to those reckless charges? I get, you know, perhaps you take intentional off, you know, just in those moments and what you see, but the fact that it was so subtle how he went about it, and it took 3 or 4 stabbings for the others to even realize what was happening, does that sort of put him on the hot seat on those reckless counts?
Absolutely. I think that's the stronger play. If Miu's going down on something, it's the reckless charges. Then that's maybe the split they make. We won't do the top of the box charges of the first degree attempted murder, but we're going to go with the reckless. Because, you know, you always talk about jurors aren't supposed to consider consequences. They're back there figuring out this is a murder one case. It may not be a death penalty case in Wisconsin, we know that, but they know it can be life. So they realize those subtleties. I thought it was really a good touch by the prosecutor when he said we'd all look down to make sure when we're opening a blade we don't cut ourselves, and he actually did that, and that would cause other people to then look down. That's what I'm going, yeah, that's common sense. You're right. People would have then noticed the knife. So again, those little things help in closing to kind of refresh the juror's memory of what's going on.
Marsh, I know everybody asks me, you know, what do you think? When's the jury coming back? They have 20 counts to go through. Again, by my loose math, I'd say they put in about 3 hours yesterday. They have 21 counts if you consider all of the homicide, the reckless, the attempts, all the way down to battery on Madison Cohen at the moment. Is there a sense that just loosely from your trial experience, you know, they obviously had a night to sleep on some of their early work overnight. Could a verdict come today? Is this one that just is going to take a while to get unanimous consent on all of the counts?
Right. As we always know, you can always have a hung juror. One juror hangs out and says, I'm not going that way. I'm going to be against all the rest of you, and I refuse to change my mind, and you get a hung jury. That's really frustrating for everyone. I try whenever possible. And, a lot of times after a jury trial, a judge may ask the jurors to invite them back in or back to their chambers, and sometimes the lawyers get to go back as well in a very kind of relaxed method to talk to the jurors about what they liked about the trial, what they didn't like. Most trial lawyers, we want to know what we can do better. Win or lose, what did you like about what we did? What didn't you like about what we did? And that also allowed us to talk to them sometimes about how they chose to deliberate. Almost always lawyers will have even a friendly bet between the lawyers about who's going to be the foreperson, because that could carry the day a lot. So when we're picking our jury in the very beginning, a lot of times we're trying to decide who's going to be the foreperson, because they can drive this case one way or the other. We kind of will take a broad brush on a lot of people and say they're just nice, open-minded people who will go either way. They're not going to be strongly opinionated, or maybe they're not real strong personalities. They're not leader types. So we try to predict who we think might be our foreperson. A lot of times the way the jurors will structure this, they go back in, they have a mountain of evidence, and they can do it any way they want. They don't have to do any of this. But my experience over 40-some years has been the jurors will go back. They might even make a list on a whiteboard about what do we have here, list of photographs, list of documents, list of recordings. They might make a whole list of that. They might make a list of the key elements, the jury instructions, the jigs, about what are the key things that have to be proved here. And they'll put those up on the board, and they can go around and do that. As you know, they're encouraged not to make a quick decision. Don't take a vote in the first 5 minutes and walk back in. So that can just take time. Between all of that, and you want to give every person the right to say what they want to say and argue back and forth. And sometimes it comes down to a spokesperson for both kind of sides of a issue, or a conviction or not conviction, and you'll have a voice on two sides. So it might not be 5 against 7. It might be 1-on-1, arguing, and everybody else is just listening.
I'm just curious. I know I do it on a rare trial. I mean, it has to be the highest of profile that I sit in for the jury selection process. But we sit in there and try to guess who the potential jury foreperson is. How often are you right?
Actually, not that, maybe better to be lucky than good, maybe, but a fair amount of times. And sometimes it's oh crap, it is the one I thought it was going to be, and now we're in trouble. So I jokingly say, and this is true, I have won trials in 5 minutes and I have lost trials in 5 minutes. They haven't even had time to go back and go to the bathroom. I mean, they're back that quick. So sometimes no matter what you do in the courtroom, they've made up their mind. There are some studies that say jurors in the first few minutes of a trial really have kind of made up their mind that you have to move them away from that. So that first impression is real important. That opening statement is real important.
Yeah, just based on community reaction, newsroom reaction, peer group reaction, this case seems to divide everybody on, where self-defense might begin, the boys' role in ratcheting up the situation. I don't know how you put 12 people in a room and get unanimous on any one topic related to this case, but that's what this jury is tasked with doing. I've been using we're running some polls on our live stream, and we've got thousands of viewers out there. We've got 5,000 plus votes already. Our team asking, when do you think the verdict will come in? Right, Marsh? This is not scientific by any stretch, but over 5,000 votes of those of you watching on our stream, and we appreciate you out there. 25% anticipating something this morning, so a quarter of our viewers expect something this morning. 45%, so nearly half this afternoon, with about a quarter, 22% saying Friday, and then another 8% don't think we'll hear from them until next week. The jury foreperson would have been selected by this point. You mentioned, how they could go through it. I mean, they had 30 pages. I have the jury instructions. I've just been reading myself just to get myself more familiar with it. 21 counts in total. So as you said, Marsh, just a mountain of work to do.
Yeah, I'll go with your 45%. I'm going this afternoon. They want to take their time, have a lunch, take a break, come back, go, anybody change their mind? We're ready to do what we want to do. And then so I'm thinking this afternoon.
And the only other tea leaves we have, I want to point out, there's no sourcing. I know I'm, a strong reporter and I have sources, but in that room, it's just the 12 and it's the deputy blocking their door. There's no outside of when they come into the courtroom to ask a question and we try to glean what that means. There's no forecasting what is happening.
No, it's an art, not a science, right?
And talk to me, Marsh. I know you're kind of a historian as it relates to the legal system, just the beauty of our system here. I asked you about it on Monday when you were with us, but this is what it comes down to. It's not a perfect system, but someone was killed on the river that day, 2 people badly injured, a couple others hurt. And now a jury of 12 peers in St. Croix County, Wisconsin, will have the ultimate say on what happened and was it criminal or was it a justified use of that knife?
Right. I think they said part of the reason this sucked everybody in, that they're so interested, there's such a big following. And thank you, just as a member of the public, for you streaming this. I think it's just a great service. People have this option to see it. But, I talk to juries about when we always are so appreciative of our veterans and our people in the service and 4th of July and all those things. We think about some of those fundamental rights of free speech or right of assembly and whatever other rights that you like to think about. Few people ever think about one of the things that our service people have died for is the right to have a jury trial, right? That you have the right to presumption of innocence in a criminal case. And this is not common across the world, okay? We tend to assume what we do is what a lot of else of the world does, and they don't. And we still have a lot of places where an authoritarian person can dictate what's going to happen to someone. So this system's got a lot of flaws. I in no way think that we can't do better, but for what we've done with a bunch of imperfect human beings, this is a pretty amazing system we've developed.
And perhaps, Marsh, you can help lead the way in opening up Minnesota courts a little more to cameras at trial proceedings, because I think it's instructive, and I certainly, Michael Waterman is running a tight ship. He trusts the jurors. He's sending them home at night. It's not a sequestered jury. It seems to have gone off flawlessly. I mean, we'll see what comes out of it on the back end, but I don't know. I'm not. I certainly have a bias here, but it certainly seems to run just fine in Wisconsin.
I think this is the case you guys should point to when you're trying to make that argument, or somebody's trying to lobby to make changes. This trial was not affected, I thought, by the courtroom camera. It was very discreetly done. The jurors weren't shown. There are, unfortunately, trial lawyers, we have head egos that we can't even fit inside the room, right? So the concern is that we're going to start trying cases to the camera versus trying cases to the jury. I thought it was interesting, Paul, you and I chatted on Monday. I talked about another trial strategy that I always like to have my clients do is generally the court will give each side of the courtroom half of the spectator section. And through the trial, from what I could tell when your camera people were scanning the spectator box, that the victim side was filled and there were only a few people on the defendant side. But you'll notice when the closings happened that defense side was also filled. So that's that subtle, again, a lot of those indirect cues you're trying to drive to a jury that this is a man respected in the community, has a lot of friends, he's a good guy. And we can, whatever side you want to kind of take in this, we're sucked in because you can see yourself being yourself or your kids tubing on the Apple River. What's more kind of wholesome Midwestern summer fun, right? So you can really see that could happen to anybody. And the same thing with Mr. Mew. Seems like a great guy, has a great life story about what he is, hardworking immigrant guy that, we can identify with him as well. So you can really start to feel the personal effects this is going to have on both sides.
Yeah, and you mentioned the tubing on the Apple River. This is, obviously local residents of St. Croix County are on that jury. And Carl Anderson, the DA, said during his closings yesterday, by his recollection, when he asked during jury selection, at least half, if not more, raised their hands if they had ever tubed down the Apple River. So it's something familiar to these people. They would know sort of the circumstances surrounding it and might inform their life experience based on the tragedy that unfolded that day. Marsh